Namaste students. I am Hans Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jayoti Vidyapith Women's University, Jaipur. Today our topic is wrongful restraint. What is wrongful restraint? In this lecture we will understand about this. Under the Constitution of India, in Article 19 and 21, every person throughout the territory of India is conferred with the right to freedom of movement and is guaranteed personal liberty. I think all of you know, you are aware about this and you have studied these Article 19 and 21 in the constitutional lectures. So you all know about these. Now, in furtherance of this objective set up by the Constitution, the Indian Penal Code lays down penal sections in case a person violates the freedom of movement or personal liberty of another. What? The Indian Penal Code lays down penal sanctions in case a person violates the freedom of movement or personal liberty of another. This is done so as to safeguard an individual's right to liberty against deprivation by another individual or groups other than a state. Section 339 and Section 340 of IPC. I repeat, Section 339 and 340 of the IPC define wrongful restraint and wrongful confinement. IPC makes wrongful restraint and wrongful confinement punishable under Section 339 to 348. I repeat, Section 339 and 340 defines about the wrongful restraint and wrongful confinement, and the punishment for the wrongful restraint and the wrongful confinement are described in Section 339 to 348. To understand the wrongful restraint and confinement, firstly, we need to understand the meaning of wrongful. What is wrongful? In criminal law, wrongful is defined as an act which is injurious, headless, reckless, unjust, unfair, unlawful, and negligent. It includes any act which is unlawful or unauthorized, or any other act or act of this nature which amount to a civil wrong. The following sections deals with the concept in detail. First we are going to discuss about the wrongful restraint. Definition of wrongful restraint. According to Section 339, what is the definition? Definition of wrongful restraint. Whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. Further, the section also lays down an exception, which is that if a person in good faith believes himself to have a lawful right to obstruct and so obstruct a private way over land or water, then it does not amount to wrongful restraint. person in good faith believes himself to have a lawful right to abstract and to obstruct a private way over land or water, then it does not amount to wrongful restraint. We can understand this through an illustration. A is walking on a public road on which he has a right to pass. A is walking on a public road on which he has a right to pass. B obstructs this path despite knowing that he had no right to stop the path. As A was prevented from passing, B can be said to have wrongfully restrained A. To establish the offense of wrongful restraint, the complainant must prove that there was an obstruction. The obstruction prevented the complainant from proceeding in any direction. The person or the complainant. So proceeding must have a right to proceed in the direction concerned. What is the objective of this section? The objective of this section is to ensure that the freedom of a person is protected. When a person has a right to proceed in a particular direction, then the law must ensure that such right is available to the person. Even if there is a slight unlawful obstruction, it is deemed to be wrongful restraint. It is neither necessary that the obstruction caused must be physical, nor is the presence of the accused essential for the restraint to be wrongful under this section. The presence of assault is not required for the act to amount as wrongful restraint. Even use of more words to cause obstruction to the path of a person may constitute as an offense under this section. When a person obstructs another by causing it to appear to that other person that to proceed would be impossible, difficult, or dangerous, or by actually causing it to be impossible, difficult, or dangerous for that other person to proceed. It must be noted that in order to invoke this section and to prove the offense under this section, it is essential for the complainant to prove his right of way over the land. Now, what are the punishment for the wrongful restraint? Section 341 of the Indian Penal Code imposes punishment against the wrongdoer under Section 339 with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. The classification of the offense under this section is that the offense is cognizable, bailable, and triable by any magistrate. I repeat, the classification of the offense under this section is that the offense is cognizable, bailable, and triable by any magistrate. It is also compoundable by the person restrained or confined. discuss about some cases regarding wrongful restraint. It will enhance our knowledge and make this section stable. Let's take a case. Madala Preya versus Verubunti in 1954. In this case, the facts were that the accused and the complainant jointly own a well, and so both of them were entitled to use the water of agriculture purpose. The accused stopped the complainant from using the water. The accused stopped the complainant from using the water and also stopped the blocks of the complainant from moving. What I said, the accused stopped the complainant from using the water and also stopped the blocks of the complainant from moving. The court held that the accused had committed offense of wrongful restraint under section 339. And another case, Shobharani versus the King, 1950. In this case, the landlord was accused of preventing his tenant, who was the tenant, from using the bathroom. By stopping the tenant from using something that he had the right to use, the landlord had committed a wrongful restraint under section 339. Further, we have another case of Sauri Prasad Patnaik versus the state of Orissa, 1989. Please, you all, the students, please write down all these cases. These are very important, and please use the AIR to understand, to study all these cases. Please write down on your notebook. I repeat, the case number 1, Madala Preya versus Vurugunti Chandraya, 1954, criminal LJ 283, Madras. And the second case was Shobharani versus the King, 1950, CRLJ 668. And further, Sauri Prasad Patnaik versus the state of Orissa, 1989, CRLJ 169, Orissa. So in this case, Sauri Prasad Patnaik versus the state of Orissa, in this case, the accused was veterinary surgeon, who did not receive payments for several months. When his superior officer visited the office and started back to go, accused stood in front of the jeep and raised protest for non-payment of his salary. In this case, the accused was a veterinary surgeon who did not receive payment for several months. When his superior officer visited the office and started back to go, the accused stood in front of the jeep and raised protest for non-payment of his salary. However, after his protest, he had given the way to jeep. The Orissa High Court held that the accused was not guilty of the offense of wrongful restraint. This is a very important case. So, I hope you have understand about the wrongful restraint. Now we will discuss about the wrongful confinement in our upcoming classes, in upcoming session. and then we will discuss about the what is the difference between wrongful restraint and wrongful confinement. So before this, this is your task for today, that all these cases which we have discussed today, please study in the library through the AIR, and write down the notes about their cases, facts and important notes of the cases. So thank you so much for watching today's classes. Namaskar.